I have our, okay. I have my office number and our fax number here, as well as my email. We also have ECI's email, earlcarlinstitute.org, where you can apply for legal services, look for general information, get shout outs for upcoming CLEs and events. So this is going to be our agenda for today. We're going to be looking at the applicable law. We're going to define evictions. We're going to discuss the eviction process. We're going to segue into tenants' rights regarding evictions during the pandemic. And we're also going to look at a special subsect of public housing evictions during the COVID-19 pandemic. We're going to look at tenant concerns, and we're going to wrap everything up with the recommendations for representation, as well as the rental assistance programs. If you have questions throughout the presentation, feel free to add them to the Q&A box, and Gloria will notify me, and I'll do my best to answer the questions as we go. Now, before we hop into the agenda, I've done my fair share of CLEs where I've been a participant, and I like a little bit more interaction. So hopefully y'all interact back with me as we begin with ECI's Housing Stability True or False Eviction Knowledge Game Show. Now, I know y'all can't hear me, or I'm sorry, I know y'all can't respond back, but try to answer the questions in the chat box. I'll give you a few moments after each question. And then don't worry if you don't know the answer to the questions, because by the end of the presentation, this should be a piece of cake. So we're going to start with our first question. So true or false? An eviction lawsuit is a judicial process to determine who has superior right to immediate possession and ownership of real property. So Gloria, if you can monitor the chat for me, and if we have some answers to start rolling in.
False.
All right, false. All right, well, let's go ahead and proceed. If you guessed it, let me see. If you guessed it, the answer is false. So I'm not going to read everything about the eviction process right now, but you're going to hear me say it probably 100 times through this presentation. Evictions are about immediate possession. They're not about ownership. So evictions, possession, title equals ownership. We're going to be in eviction land, so we're going to be looking at possession. And we're going to see if we got another one. Oh, we have another question lined up. So true or false? Generally, a landlord or property owner must give a tenant or occupant a 30-day notice to vacate prior to filing an eviction lawsuit. So again, Gloria, if we have some answers start rolling through. Try to make this as interactive as possible.
True.
Okay, we got true.
True. We have a false.
All right, so mixed responses on this one. That's what I like to hear. All right, so the answer is false. Generally, the landlord gives a 3-day notice to vacate, but you also have to be mindful to look at your lease contract, because it could be a less time that's in that lease. If you said 30 days, you're probably thinking about the CARES Act for the federally funded mortgages or federally funded, what do you call them? Landlords that have federally backed mortgages. So keep in mind, CARES Act has kind of expired at this point, but there are some residual things that are still lingering there. Let's see what else we have lined up. So true or false? It is permissible for the landlord or property owner to mail the notice of vacate to the tenant or occupant. Got any answers yet, Gloria?
We have true, false, true.
All right, we have another mixed response. This one is true. So we're going to talk about delivery methods in regards to the notice in great detail later, but just know that the landlord can mail it, and there is a presumption that when the landlord mails it, it's going to be presumed to be proper delivery. I think I have one more question lined up for you, and this will be our little end of our game show here. So a lot of crowd participation. A tenant can assert a counterclaim against their landlord in an eviction case. If you're not certain what a counterclaim is, that means that the tenant is allowed to sue their landlord in the eviction case.
We have a false.
All right, we have a false. All right, and before we wrap this on up,
False.
there is no drum roll. If I knew how to make the drum roll sound, but I can't. But the answer is false. So in eviction cases, the court can only adjudicate possession and not title. Now, counterclaims are not permissible in eviction cases, but they can be filed in a separate action. So just keep in mind that evictions are just going to be about possession. They're really specific and really limited. So now we will kick off into our presentation with the applicable law, like, where do I find the law on evictions? So we're going to look at the Texas Property Code. We have a few different chapters that apply to evictions. We have Chapter 94, that's going to be the forcible entry and detainer, or the fancy way of saying evictions. We have Chapter 91, which talks about the provisions applicable to landlords and tenants. You'll find a lot of definitions and procedure in that section. We have Chapter 92 that talks about residential tenancies. I didn't include it, but we also have Chapter 93 that talks about commercial tenancies. And Chapter 94, we're going to be dealing with manufactured homes, trailers, and when you're renting land, when you actually own the manufactured home. We also have some procedural rules in place when it comes to eviction. So we have rules 500 through 510, but specifically 510 is where we're going to file, or we're going to find the rules for evictions. Another place that we're going to look when it comes to evictions is going to be the residential lease agreement, i.e. contract law. And the last place that we're going to be looking to for the applicable law is going to be those Texas Supreme Court emergency orders. So there's a link there. I won't go into too much detail, but I believe that Gloria will be emailing out the presentations after this. So if you so that you'll get my. And we're dealing with several civil procedure 500 through 510. Now, because we're dealing with evictions, if there's any type of disconnect between rules 500 and 507 and 510, 510 is going to control. That's what we're talking about, specifically evictions. Who's the plaintiff, who's the defendant, what needs to be in the petition, the timeline, all of that good stuff that I won't bog you down with. We also have in 500.4, that's what we're talking about, representation. So just know that if you are facing an eviction, you're representing someone in an eviction, you have a friend going through an eviction, the tenant can represent themselves. They can be represented by an authorized agent. They can have an attorney. And in some situations, we can look at assisted representation by a family member or another close relative or friend. Make sure that family member or friend is not being compensated for that representation. If they assist, we kind of get into some unethical issues, maybe even unauthorized practice of law. So be mindful, if you help a family or friend, you can't charge them, because at that point, you are practicing as an attorney without a license. Now, when we look at the landlords, they're typically going to be corporations or some other business entity. So they can be represented by the property manager, their authorized agent, it might be their, or an attorney in an eviction case. Now, chugging along, we're going to start looking at the jury demand. So even in an eviction case, you have a right to a jury. That's a constitutional right there. And the jury filing fee is $22. So if you request a jury, that means that a panel of your peers will decide the case, not the judge. Now, if you can't afford that $22 fee for the jury, don't worry. We don't discriminate because of someone's ability to pay. You can file an affidavit of inability to pay, or typically you might hear a pauper's affidavit. So just know that you are entitled to a jury trial should you want one. There's different strategies in requesting them as well. Now, when we're talking about procedural rules and jurisdiction, now justice courts have original jurisdiction over possession issues. So that's going to be eviction. The district courts are going to have original possession or original jurisdiction over title issues. So if there's a dispute about who owns something, we're not going to be in eviction world. We're going to be in title world, and that's going to be in a district court. Now, keep in mind that if there is a pending case in district court in regards to foreclosure, for instance, it doesn't necessarily automatically mean that the justice court does not have jurisdiction. If you're going through a foreclosure and there's no title dispute, you can still be evicted. But when you're looking at jurisdiction, you want to be sure to look at these cases carefully, because there's possible, defenses. When eviction suits move very quickly from the time of service of the notice to vacate to the actual judgment. So we want to take full advantage of any defense that we can find, because evictions have a lot more repercussions than people give them credit for. All right, whoops, there we go. So now we're going to be looking at what is an eviction. So eviction, that's a judicial process by which an owner recovers possession. It's highlighted, it's bigger, it's in red. I want you to remember possession. In addition to the eviction with possession, they can also get a judgment for the past due rent, if there is any, attorney's fees, if they have an attorney representing the landlord, and they can get court costs. So for the money that they had to pay to bring to file the case against you, if you are a defaulting tenant or occupant, then it's typically about $121 there that can be entered as a judgment against you. Now, the property owner or landlord may file an eviction lawsuit against the tenant for breaching the lease agreement. So these breaches are going to be like maybe failing to pay your rent, or failing to comply with some other provision of the lease agreement. So keep in mind that, there are many reasons that you can be evicted. One defense that we like to look at in eviction lawsuits is that the landlord or property owner, they must name all individuals on the lease. So if the lease has 5 people, they have to say something like tenant and all of their occupants, or name all 5 people. If they only name one, then it's presumed that they only want to evict one. And the other 4 people that's on the lease agreement, they would have to bring a separate eviction action against them. So again, you want to be sure to look at what's actually said on that petition, but we'll get into more of that as we keep going through the presentation. Now, as we're talking about evictions, most of them are going to be for non-payment of rent. At the heart of it, we have a contract. You get the tenant gets the place to stay, the landlord gets, the money. So most things the landlord's going to be upset about to where they want to file an eviction is going to be non-payment of rent. But don't get confused and think that that's the only reason. We're going to be looking at violations of the lease agreement, illegal activity. Maybe there might be some drug activity. We're going to be looking at health and safety violations. So maybe if you've seen the show Hoarders before, we have some safety concerns there, maybe some fire hazards. We're going to be looking at threats or unsafe behavior. So if you have a tenant that is maybe threatened to harm the staff that works at the apartment complex or something of that nature, we're going to be looking at providing false information on lease applications as well as a ground for an eviction. So keep in mind that application is going to follow you. If you lie on the application and you use some type of fraudulent means to acquire the property, there could be repercussions on the back end. And sometimes we have these HOA rules. So there are some tenants that rent houses, and these houses are going to be in communities that have HOA protocols to follow. So if you got to follow those protocols in addition to your lease language. So you want to be careful to read your lease agreement in its entirety, so you know exactly what is a violation, what's not a violation, and what the landlord can evict you for. All right, so now on the screen, I know it's kind of small, but this is an example of the eviction petition. So like in the top right, you'll see that's the case number. When the landlord files, it's going to be blank. The court clerk will fill that in. On the left side right there, you'll see like the landlord, that's going to be the plaintiff, and the tenant's going to be the defendant. If you look down a little bit at number 1, we have like the name of the tenant that has to be provided and where they're going to be served. Typically, they're going to be served at the location that they're renting. But for whatever reason, they might have a different mailing address. You have to identify the premises to make sure that the justice court does have jurisdiction over that particular address. And you're going to be looking at the grounds for eviction. This is an area that we like to look at when it comes to eviction defense, especially because we want to know why the landlord wants to evict this person. Is it for failing to pay rent? If so, how much? When was the last rental payment? Do they have all the money calculated? We want to know if they want to evict them for lease violations. If so, what provision of the lease are they relying on? Are they evicting the tenant as a holdover? So that means that your lease has expired and you no longer have permission to be there. Are we evicting them for foreclosure? So we want to make sure that we identify the reason or the grounds for eviction. Lastly, we want to know if there's going to be that notice to vacate. That's going to be like one of our biggest areas that we're going to look at for eviction defense. We want to know when it was delivered, how it was delivered. Like the notice to vacate is going to be very crucial in understanding as we keep going through the presentation. Lastly, with the attorney's fees, they have to actually have an attorney representing them. Sometimes you have landlords that like to get slick and have an authorized agent that's not an attorney and request attorney's fees. It's attorney's fees, you have to be an attorney to recover them. So keep that in mind. If you get this petition, you want to study it, you want to, digest it, you want to know exactly what's happening. Now, we're going to be looking at who may file the eviction suit. So that's going to be the plaintiff. So the plaintiff has to have an ownership interest in the property or be the authorized representative of the owner. Now we're going to be looking at maybe the property manager, or maybe if the CEO of the apartment complex is their authorized representative, they have to be someone that the plaintiff has authorized to represent them. That's going to be another potential defense right there, is if there's not an ownership interest. So let's just say person A sues you for eviction, but person B is the person that actually owns the property. Person A can't evict you from something that they don't own. So we want to, there's a lot of potential defenses and, throughout this process, but you have to know what traps to look for. You have to know exactly what you're looking for when it comes to defenses. Now we're going to talk about jurisdiction. So justice courts or justice of the peace, they have jurisdiction over eviction actions up to $20,000. Now, some of you are aware, we've been dealing with the pandemic for over a year at this point. So we actually have individuals that have been unemployed, unfortunately, haven't been able to pay their rent, and their rent might be unpaid for 15 plus months at this. Now the land recover lawsuit. If there's more, you might have to look at a jurisdiction. The eviction can't be filed in the justice of the peace court. They might have to file it in a different court. You also want to look at the jurisdiction for a defense of the justice court where the property is located. So the proper venue for an eviction case is the precinct where the property is located. So if the property is located in precinct 7, for instance, then the landlord can only file the eviction in precinct 7, place 1, or precinct 7, place 2. Now, if the landlord has a buddy over in like precinct, 2, for instance, they don't get to just, go over to precinct 2 and file the eviction. That court doesn't have jurisdiction. Now, if it appears as if the court's jurisdiction is an issue, then you want to file a plea to the jurisdiction, and that challenges the court's authority to hear the case. If the court doesn't have authority to hear the case, the court doesn't have the authority to make a decision, regarding the outcome. Also, a side fun fact here, probate courts sometimes have jurisdiction in an eviction suit when the personal representative of an estate is a party. It doesn't happen very often, but there is a slight overlap in who has jurisdiction over evictions at times. All right. Now, when we're looking at probate and maybe some title issues in eviction cases, again, eviction, we're looking at possession. So the only thing that we're concerned about in an eviction lawsuit is who has the superior right to immediate possession. There's no title, we can't, so typically probate and title issues can't, they don't come up in eviction cases. We can't bring in counterclaims, we can't join in other lawsuits against third parties. Eviction is just about possession. Now, if you have a claim that you want to bring against your landlord, maybe for a constructive eviction, or maybe a wrongful eviction, or maybe some damages they owe you because you had to replace the fridge, or you had to replace the roof or something, and they, you can file that lawsuit separately. You just can't combine it with the eviction case. Again, justice courts or justice of the peace courts cannot adjudicate title. They can't determine ownership. So if it's anything with title or ownership, you can't have that case in the justice of the peace courts. Now, what is the federal, government doing about evictions during COVID-19? So before, we heard a lot about the CDC. So the Center for Disease Control and Prevention, They previously had like a residential eviction moratorium to help, to stop or prevent the further spread of COVID-19. Well, unfortunately, back in August, the US Supreme Court struck down the CDC eviction moratorium, so we no longer have that protection available. Now, those cases that were previously placed on hold or vacated or abated, suspended, whichever words you want to use, the ones that were paused pursuant to that CDC declaration, they're no, that's no longer an adequate basis. So if you have a different reason, like rental assistance, or you have an agreement with your landlord, then the case might be abated or suspended or paused, but the CDC declaration is something that we can't hang our hooks in anymore. So those cases are moving forward, and a lot of those individuals that were relying on the CDC that didn't have any other defenses have likely now been evicted, or if they didn't come up with some other arrangement with their landlord. Now, what are Texas courts doing about the evictions during the pandemic? So we have the Supreme Court of Texas that has issued like several emergency orders. So right now we're on emergency order 42. Now this order deals specifically with like the Texas eviction diversion program and rental assistance that are available for tenants and landlords. So a lot of the justice courts are trying to persuade landlords and tenants to participate in these rental assistance programs so that the landlord has an opportunity to get paid for the past, delinquent rent, and the tenant has an opportunity to, remain in the property, keep their house, and not have an eviction judgment against them. So if we have a situation to where the landlord and the tenant are agreeing to participate in these rental assistance programs, or maybe the tenant has already applied for rental assistance and they're just pending approval, there's the case has to be abated for 60 days. So that means it's going to be placed on pause for 60 days, and that gives the rental assistance programs times to work. Right now, I know, for instance, like Texas rent relief is taking like 4 to 6 weeks to pay out. So that 60-day period is crucial for a lot of tenants that are waiting on rental assistance. We're going to talk about different rental assistance programs and where to find them and different requirements a little bit later in the presentation. One thing to also keep in mind when we're talking about a case that has been abated, when it's abated for 60 days, the case is actually supposed to go into confidential status. So that means that no one will be able to look it up because it won't be a public record. Now, for whatever reason, if the rental assistance pays out, or maybe the landlord just forgets about the case, after that 60-day period, if nobody takes any action, the tenant is actually able to proceed to have that case dismissed with prejudice, which means that the landlord can't refile. So there's a lot of hidden gems right here in the Supreme Court emergency orders. So you want to definitely look there when you're looking at eviction defense. Now, we're going to be talking about the process for the eviction because it moves quickly. So if you don't know the process, we want to, it's going to be something that is of the utmost importance, whether it's your first time representing a tenant, whether you do it all the time, it's a nice refresher, or whether you're going through an eviction right now, it's information that helps everybody. So the first thing that, kicks off an eviction case is going to be that proper written notice to vacate. Notice that proper is highlighted. Now, keep in mind, evictions are, they're statutorily defined and they require strict statutory compliance. Strict means strict. So if the notice says it has to be in writing, the landlord can't text you. We're talking, put pen to paper writing. If the notice to vacate says that it has to be placed on the inside of the door, we mean the inside of the door. We don't mean, pushed through the crack. We don't mean under the doorknob. We don't mean floating outside your door. Strict compliance is strict compliance. And that's landlords tend to be lazy. So that's something that we definitely look at when it comes to eviction defense. That notice to vacate, we're going to look at delivery. So it can be, typically it's going to be mailed, delivered to the person, or delivered to the property. When you deliver it to the person, you're going to give it to the tenant, someone on a lease over 16. That's, deemed proper delivery. If you mail it, best practice would probably be to mail it certified mail, return receipt requested, but that costs money and landlords do not typically do that. But they can do first class mail or just even regular mail. They get the presumption of proper delivery if they mail it. And the other, delivery is going to be delivery to the property. So when I say that it has to be posted inside your front door, that means that they have to actually turn the doorknob, open the door, post it in the main entryway. A lot of landlords don't like to do this. They'll say it was posted on the inside, but it wasn't. So that's one of our biggest defenses that we look for. And that's something that you should look for if your landlord's giving you a notice to vacate, or if you're going to be defending a tenant that's going through an eviction. Now, the notice to vacate is not the date when the tenant's going to be kicked out. So if the notice to vacate says you have until November 5th to leave, November 5th is not your kickout date. That's just the date that the landlord has before they can file the eviction case in the justice court. If you do happen to vacate prior to that, it doesn't mean that your problems are all gone. It just means the landlord can't file an eviction, because at that point, the landlord has recovered possession of the property. If the deadline to the notice to vacate does come and the tenant is still in possession of the property, then the landlord must go to court to evict the tenant. So after the notice to vacate, the landlord's gonna have to, go to the justice court and file the petition that we talked about earlier. So again, if the tenant fails to move out before the deadline, then that's where the eviction is going to be filed. After the case is properly filed in the correct justice court, then the tenant's going to be served with citation. The citation is typically going to come from a constable or some other law enforcement officer, and it's going to have your eviction, it's going to have your court number, and it's going to have your court date. Now, on that eviction citation, it's super important that you pay attention to that court date, because we don't want you to have a default situation. If the court date is for November 5th, you have to show up to court November 5th ready to go with all your evidence. On that same date, landlord has to be ready to go. So if you have defenses, if you have, hey, I paid the rent, here's my receipt, whatever you have on that date, we got to be ready to go, because we're going to trial. Now, I just wanted to add this slide because some tenants confuse notice to vacate versus the eviction. That notice to vacate is the document that you get before the eviction lawsuit is filed. It's really, really common for tenants to surrender that at the deadline for that notice to vacate, because they feel that they've been evicted. But they're unaware that they still have rights. You have a right to a hearing, you have a right to defend yourself. If you vacate that property before the eviction lawsuit, then you no longer have any legal remedies, because there's no longer an issue. Again, evictions are about possession. So if the tenant vacates prior to that court date, there's no issue, because the landlord already has possession back. So keep in mind that if you want to assert your rights, if you want to show your receipts that says, hey, I paid, or if you want to go to court and say the rental assistance program's paid, or if it's for another lease violation, you want to bring whatever evidence you have to that court date. Now, we're going to talk about, briefly, or just reiterate, like what the landlord can evict you for. So can a landlord file an eviction against you for other violations outside of non-payment of rent? Yes, we discussed that previously, where we have lease violations, HOA rules that are not complied with, illegal activity, unsafe behavior, health and safety concerns. Common examples of lease violations that we see a lot are unauthorized occupants, unauthorized pets. So if you have a dog, but you don't pay your pet deposit, or if your apartment requires you to pay like monthly pet rent, which I think is egregious, like you have to pay for yourself and you have to pay for your animal, that's a lot. But if it's in your lease contract, it's in your contract. They also look at criminal activity. So there's a lot of reasons that people can be evicted. The lease agreements are typically at least 8 pages with like really small print. So there's a lot of information jam-packed into that lease agreement. Now, what happens if the tenant does not leave by the date on the notice to vacate? So what happens if you don't vacate is we're going to trial. Now, your trial date comes from that eviction citation that's going to be delivered by the constable. The constable is going to serve you. They're going to serve somebody at the house over 16. They're only going to try so many times. So after so many failed attempts, then the constable can actually, post it on your door or slip it underneath your door. Now, don't get it confused that the landlord can do that. The landlord has, strict compliance with how they can serve you with that notice to vacate. Don't get confused that notice to vacate and that eviction citation, because they're two separate documents that have different delivery methods. Now, can a landlord physically remove a tenant from the residence? So I don't know if y'all are like me, but I watch a lot of movies, and you'll see like a movie in like New York where someone will go home, or they're coming home from work and their stuff is like outside on the curb. And it's like, I'm talking like mattresses, bedposts, TVs, like it's just on the curb, like, you know, they treat it as if it's trash. Those are called self-help evictions, and we cannot do a self-help eviction in Texas. The landlord is not allowed to remove your belongings or you from the property. If the landlord does attempt to remove you or your property from the leased premises, they're going to be facing potentially, you know, consequences down the road. You know, you might have some unlawful touching. It could be an assault. It could be a battery. I'm not a criminal attorney, but just know that self-help evictions are not permissible in Texas. The landlord cannot physically remove you or your belongings from the property. Now, we're going to be looking at continuing, like what happens after that notice to vacate. Now, if and you're evicted. So let's say you go to court, the judge enters a judgment for the plaintiff or the landlord. Now you have the right to appeal. When you appeal, it's going to be reviewed de novo. So that's a fancy way of saying a Latin phrase for like new trial. So you get another bite at the apple. We're going to start everything fresh with a new judge and a new court. Now, the appeal deadline is really quick. You have 5 calendar days, not business days. It includes weekends. We're talking if it happened on Sunday, we're going to count Monday, Tuesday, Wednesday, Thursday, Friday. Like you have 5 literal days to file the final to file the appeal from the date of that final judgment. The tenant's going to be required to pay either a cash bond or some other amount that's set by the court. If they can't afford that cash bond or appeal bond, the tenant can file that pauper's affidavit or the sworn statement of inability to afford court costs. If you do file the pauper's affidavit or that statement of inability to pay, that's going to be like a substitution for the appeal bond. And, you know, that's what you need to perfect your appeal. So that's the way of saying that you have done everything that you needed to do to have the county court hear your case. Now, if you use that pauper's affidavit, there is a right for the tenant to request the attorney be appointed to represent them. We don't want individuals' ability to pay to prohibit them from, you know, legal remedies that they might be entitled to. Now, keep in mind that if you are evicted for non-payment of rent, there's kind of a gotcha. Even though you filed that statement of inability to afford court costs, or you pay the appeal bond, you still have to pay rent to the court's registry. So you don't pay it to your landlord, you're going to pay rent to the court. And that rental amount is going to be set by the justice court. So it's kind of a hard situation if you're evicted for non-payment of rent, because more than likely you don't have the rent to pay. But it does give you an opportunity to try to do what you got to do to pay that first month of rent, because typically a lot of tenants are needing time. You know, that 60-day abatement period is helpful, but there's a lot of rental assistance applications and time is not on your side during an eviction case. So you want to do the things that you need to do to buy yourself as much time as possible so that you can either find alternate housing, give the rental assistance programs time to pay, or, you know, make other arrangements for your family. Another fun fact to keep in mind is if you're part of your rent's paid by the government, like if you're on maybe some type of public housing, the court will state how much you have to pay during the rent. So if you're only required to pay 25% of your rent on regularly, if it's appealed, you still pay that same 25%. If you completely ignore your eviction suit, so you don't go to court, you don't file appeal, you don't do anything, you just kind of sit on your hands and twiddle your thumbs, then the landlord is likely going to get a default judgment. Once they get that default judgment, then we're going to be looking at the writ of possession. So that writ, or is going to be a fancy way of saying order. That's going to direct the constable or other law enforcement to come to the property. They're going to give you a 24-hour notice to vacate. If you don't vacate after 24 hours notice, then the law enforcement officer is actually, you know, they have the authority to remove you and your property from the premises. We don't want that to happen. So definitely reach out for legal assistance if you do find yourself facing an eviction. If you're in public housing, the same rules typically, for the most part, apply. Now, public housing is governed by federal law, so there are other certain protections that apply. I'm not going to go too much into it because that's a whole nother, CLE presentation that we can get into. Typically, the notice requirement is a little bit different for public housing, but overall, Texas Property Code, Texas Rules of Civil Procedure, they still apply to public housing. Now, if you're on public housing and maybe you've lost your job or maybe you have a reduction in hours, what you should do in this situation is you want to arrange an income recertification with the Public Housing Authority as soon as possible. The sooner you request that income recertification, the sooner they can adjust your income responsibility so that you're not on the hook for the same rental amount that you can't afford. We want it to be proportionate to what income you're actually earning. And keep in mind that the federal stimulus payments are not going to be included in the income calculation for public housing recipients. Now, what we're looking at in this part of the presentation is a little bit more about ways that landlords try to force tenants out. So what they like to do is if you're not paying rent, they don't want to continue. They want to find a way to make you leave without having to actually file the case. So a landlord will disconnect your utilities and just know that this is a violation of the Texas Property Code. They can't terminate your lights, your water, your gas, any utility for not paying rent. There are permissible reasons, like if they want to work on the plumbing or if they're trying to work on the electricity or something, but failure to pay rent does not mean that you get your lights cut off if your landlord is responsible for maintaining those lights. Now, if your lights are separate and then you have a contract with CenterPoint, you don't pay your bill, you're going to have to deal with CenterPoint for that. But if your landlord pays your utilities, if you have all bills included, for instance, and you fail to pay your rent, that's not a justification for the landlord to terminate your utilities or interrupt them in any way. If a landlord does do that, a tenant can file a writ of restoration. It's something that can be done by themselves. You're going to have this ex parte hearing, which means you're going to go to the judge one-on-one, and you're going to present credible evidence that your lights have been terminated. And if the judge finds belief that this has happened, you're going to issue restoration, and it's going to direct the landowner or property owner to reconnect the lights or whatever utility that they've interfered with. This is a sample writ of restoration. This one's dealing with electrical services, but you also have water, gas, sewage, any utility that the landlord's responsible for maintaining. So you want to set forth like, hey, the property is located here. The landlord's responsible for maintaining this utility. On this date, the landlord terminated my lights because I didn't pay rent. And what happens after you file this writ is that the judge is going to order the landlord to temporarily restore the utility pending a final hearing. Now we're going to segue a little bit to what are we going to do if a tenant or family member has been diagnosed with COVID-19. Just know that being diagnosed with COVID or being in contact with someone with COVID is not independent grounds for an eviction. So if you haven't violated your lease in any way, simply testing positive for COVID or coming into contact with somebody with the coronavirus is not grounds for an eviction. Now, what we do recommend is that you continue to follow the guidelines set forth by local government and public health officials. So if you've tested positive, social distance, quarantine, do all the things that you need to do to keep yourself safe, keep your family safe, and keep the public safe. Because we all want to come, at the end of this, we all want to be in good health and in our homes still. This is one section. So there's kind of like a miscellaneous section of like, what can the landlord do? Like, can the landlord take your personal property if you don't pay rent? Now, the quick answer is yes, but there are some things you have to know about this. The landlord they do have the ability to place a lien on your tenant's personal non-exempt property. I'm going to detail like non-exempt property later, probably in the next slide or two. But if you don't pay rent, the landlord probably can attach a lien to your personal property, your non-exempt personal property. This ability to exercise this right has to be in a lease agreement. It has to be underlined, bold. It has to be, you have to be on notice that the landlord is attempting to use this right. So if they put it like in like 8-point font in like the bottom of the page, like in some real, if they try to hide it, that's likely not going to be enforceable. But if they have it, 20-point font, underline, bold, and you just fail to read it, then that's going to be something that you're going to have to be wary about if you are delinquent on rent and the landlord does choose to exercise this right. Now, when they do, if a landlord does seize your property, just know that they do have to leave written notice that they've come into the property, they've made entry into the unit, and they have to leave an itemized list of items that have been removed. So we don't need to just go into your place and have a free-for-all. They need to let you know they've been there, and they need to let you know what they've taken, if it ever does come to this situation. So here's a list of exempt personal property, and you're going to find this in chapter 42. So if you're bored one night, want something nice to read, chapter 42 is it. So we're looking at exempt property. We're going to be looking at home furnishings, talking about family heirlooms, food, farming and ranching equipment, because we like to keep our trades and the ability to make money. Motor vehicles, boats, anything that you use for a trade is going to be exempt. Tools, equipment, anything like that. Wearing apparel. We got some jewelry that's going to be falling under the exempt category as well. And because we're in Texas and we love our guns, there's firearms that are actually exempt as well. Now, there are some concerns that people will ask about these commercial commercial tenancies. Does anything that I really discussed today apply to those commercial leases? No, typically not. The emergency orders, they're going to apply to residential property. Right now, we're trying to do what we can to keep people in their homes, and businesses are not included in those protections. There are some other protections available, and you might be able to look at the American Rescue Act, or just do a Google search. I love Google. It's fantastic, and you can find a lot of resources just by making a quick search. Is there other assistance available? So when we're talking about commercial leases or just in general, there are some relief programs that are established under the CARES Act that still have funding. They're still going. So whether you have a residential lease, a mortgage, or a commercial lease, there are different programs available for different types of situation. Even for tenants that do have public housing, there are some assistance available for them as well. Now, landlords can typically be eligible for mortgage forbearance, small business loans, PPP loans. There's other grants provided under the CARES Act. We also have the American Rescue Act. So there's a lot of resources available. It's just a matter of knowing where to start. There's even some smaller community organizations, churches that make pledges, donations. There's a lot of resources available for tenants, for landlords, property owners right now. This is a list of like the rental assistance programs for tenants that might be facing eviction. For the most part, Texas rent relief is kind of where it's at right now. There's a lot of funding. I think there still might be an excess of, I think maybe 1.1 billion that's still waiting to be dispersed. I'll have to double check that number. If you're outside of Harris County, there's resources available here at Fort Bend County, or if you're in Galveston County, look at Galveston County resources, Waller County, whatever county you're in, there's rental assistance programs available. Texas Law Help, there's resources for, information, rental assistance programs that's going to kind of give you kind of the way to approach a case like pro se if you don't have an attorney. For sure, reach out to us if you need representation for any reason, and we can go through our process to see if you're eligible for services. There's also the Houston-Harris County Emergency Rental Assistance Program. They also have funding. I believe that Texas Rent Relief and Houston-Harris are able to pay up to like 15 months of back rent, 15 months of rent. And that includes the current month as well as 2 months rent. So I think in total, they're paying at least up to 12 months of delinquent rent. So that's a lot of money that's on the table, and it keeps people in their homes. If you are facing an eviction, there is a special subset of money set aside for the Texas Eviction Diversion Program. And that's specifically for tenants that are currently in the thick of an eviction case. We don't want you to be evicted. We don't want, we want the landlords to be paid. We want to keep people in their homes. So these are a lot of resources available that you can check out. Now, the end part, so we're going to be looking at representation recommendations. So I've done my fair share of eviction cases at this point. And first and foremost, due diligence and an understanding of the law is key. You want to look at that petition. You want to know the notice to vacate. You want to know how it was delivered. You want to be able, if you're representing a tenant, you want to be able to cross-examine, the property manager that, potentially says that they delivered that notice to vacate, because more than likely they didn't. You want to know the dates, the times, like you want to do your due diligence and be prepared, because eviction trials move quickly and they have a lot of, repercussions that affect tenants in more than one area. It could affect their credit. It affects their ability to find future housing. It determines where they can move to, because a lot of landlords don't accept evictions. So you definitely want to do your due diligence, understand the law so that you can advocate for your clients. Excuse me. You also want to understand that your client's facing other personal issues. So if you're facing an eviction, more than likely you have issues with utilities, and there's a lot of other social justice issues that are happening. So you want to, understand that your client, although they're facing an eviction, there's current consequences of being evicted and there's future consequences. You have credit issues that can happen, the ability to find future housing, potential homelessness, shelters. There's a lot of things stemming from evictions that you have to be mindful of. You want to, if you're an attorney or maybe legal aid, or I'm sorry, just an attorney, you want to look at providing pro bono services, or maybe even a discounted rate. I'm going to be like on the high end. I know for certain less than 10% of tenants are represented in eviction cases. And if you go to a docket, you can easily have 50 people and watch 45 people get evicted in less than an hour total. So representation is key. And 10% is on the high end. I think it's probably actually lower than 5% of tenants are actually evicted. Now, with the pandemic and access to Zoom hearings, a lot more tenants are showing up and, being able to exercise their rights, but we're still, a very few tenants are actually represented during this process. You want to always remain empathetic to your client situation. No one wants to homelessness, to check your privilege and to understand where your client's coming from, because it wasn't necessarily an overnight decision that got them there. And when you're kind of berated during this process, I've heard judges say things that weren't kind to tenants and make assumptions about people's money and what they're doing and what's important. And you don't want to be the person that's representing them and, perpetuating the problem. You also want to consider alternative dispute resolutions, mediation, arbitration. These are different mechanisms to keep tenants in their home and facilitate agreements between landlords and tenants, because landlords want to get paid. And we understand that they want their money, and there's money out there and available. We also want to keep tenants in their home. We want to keep their records clean. We don't want to have judgments against them. So sometimes it's just as simple as facilitating negotiations between landlords and tenants. And there's also a lot of rental assistance programs that have a lot of money still available for at-risk tenants. So you want to apply. You want to apply ethically because there are, potential criminal liability that tenants can face, and that maybe you can face if you're assisting someone, present false information. So I believe that we have come to the end. So thank you for coming to my presentation about evictions and the continuing impact of the coronavirus. And I'll open it up for questions if we have any at this time, Gloria.
We do not have any questions at this time.
All right, so I'm going to take that as I did a super great, fantastic presentation, because no one has questions and I answered anything you could have possibly thought to ask. So no questions is a good thing for me.
Okay.
So again, thank you for coming out. And I believe Gloria is going to talk about our upcoming CLE presentations as well.
Yes, give me 1 second.
Oh, let me stop sharing. How do I do that? Oh, maybe you did it for me.
This concludes our CLE today. Thank you to our attendees for your participation. And our upcoming CLEs are October 22nd, 2021, Housing Stability on Foreclosure Defense. And if you put your phone to the QR code, it will redirect you to register for that CLE. And then the following one after that is October 29th, our Juvenile Justice Defense. And for any upcoming events and what's going on with ECI, please follow us on Facebook. And I can give y'all a few minutes if y'all want to sign up. Does anybody have any questions? I will be emailing the presentation materials, attendance form, and evaluation forms. Again, thank you all for coming.
Thank you too.